All right. Well, in interest of getting started pretty close to on time, I'm sure there'll be people still jumping in. Good morning for some. Good afternoon for others. My name is Ryan Schley. I'm with CPT Group. I'm an attorney and vice president of sales and development, along with my counterparts, Nick Day, Timothy Phillips, and Alan Rock. I'd like to welcome you to this first part of a three-part series that we are doing on Chapter 11, Bankruptcy Subchapter 5. I would like to welcome you all, and I'd like to introduce our speaker to you. First, let me tell you, CPT Group, we do claims and notice. So anybody who's out there looking for a claims and notice agent, we're approved in every court in the United States, and we're here to help you in any way we possibly can. So let me introduce our speaker. Michael Jones has been practicing law in California since 1993 with a primary focus on bankruptcy for most of that time. He teaches CLE courses on various Chapter 11 matters. He's tried multiple Subchapter 5 cases in California and published articles on multiple occasions on both Chapter 11 and Subchapter 5. And he's gonna take over in a second, and then we're gonna at the end of his part of the presentation, he's gonna open it up for questions. So feel free to ask any questions. He's done this in the practical world, so he's a great resource for us, and we're really happy to have him. So Michael, take over.
Hey, so good afternoon or morning, depending upon where you are. I'm here on the left coast, so it's still the morning for us. We got about an hour or so to go through. We're going to actually end up spending probably about 50 minutes or so on substantive matters, and then we will have some Q&A time so that we can see everything that's kind of going on in the real world out there in the trenches so that you guys know what's going on. Let me tell you that I've done a whole bunch of these Subchapter 5 cases, so I've confirmed quite a few. They are brand new, meaning that they're only about a year or so out. So of course, bankruptcies existed in our country since the absolute very beginning. It's even made reference to in the Constitution. So Congress makes uniform laws for bankruptcy for all the states. And within that, we now have Subchapter 5. So what I'm going to do in our time together here right now is I'm going to take us through some of the big differences between Subchapter 5 and then what I will call a traditional Chapter 11 case. As we move through this, you'll be able to see that it really is a unique critter and has a lot of very interesting opportunities to the debtors that are available to it. So in my personal practice, we are primarily a debtors counsel firm. So we do the occasional creditor, but not much. We're mostly a debtors guy. But Subchapter 5 has unique application in that it is targeted for a very specific kind of debtor. So you may be familiar that Chapter 11 has other subchapters in it that are specific to particular debtors, the most notable of those being railroads. Now, as we go into this, the first thing I need you to be aware of is that there have already been significant changes to Subchapter 5. So the two biggest ones are the definition of a debtor and then also the debt limits that are available for people who are eligible. So just make sure that the copy of the code that you're using is in fact the 2021 copy of the code and not the 2020. So 2020 will be just a little bit out of date on a couple areas. So again, make sure you're using the right one. Also, when you're looking for Subchapter 5 and you need to know the laws that apply to it, as you would expect, most of the laws are in Title 11. So Subchapter 5 of Chapter 11 of Title 11 is contained in sections 1181 through 1195. But there are other references within the code too, mostly in Title 28, which is the U.S. code related to the courts. Of that one, the bullet that's there on the screen, the second one is very notable. There are no U.S. trustee fees in Subchapter 5 cases. Okay, so that factors into your issue as to whether or not we should file a traditional 11 or whether we're going to file a Subchapter 5 case, because the U.S. trustee fees went up rather dramatically about a year or so ago. And if you're going to be liquidating a large piece of real estate or something like that, your U.S. trustee fees can be substantial. So that's one of the factors that you'd want to keep in mind. And then also, just to kind of protect my trustee friends, the ones who are the Subchapter V trustees, there is provision in the code for paying these guys, even in the event that there is a dismissal or a conversion. So that's also contained within Subchapter 5 or within Title 28 related to the payment of trustees. All right, now give you a big picture event. If you look at Subchapter 5 like it's a trip, you might look at it as having 4, maybe 5 major stages. Okay, so the first stage of any trip is deciding where are we going to go. Okay, should we take a trip? And if we do, where are we going to go? In the planning stage of a Subchapter 5 case, you kind of got to look at whether or not you're a good candidate for a Chapter 11 case of any kind, whether you meet the definitions of a debtor and you're under the debt limits for a Subchapter 5, and start thinking about what it is that you plan to do within the plan. So you might start already thinking about classification of creditors, who we're going to group together, whether we're going to do anything super aggressive, whether we're going to try kind of segregating and gerrymandering a little bit, see if we can pull that off. You're also going to be wanting to be thinking about the terms of your plan geared more towards a consent plan as opposed to a contested plan. And there are significant reasons for that we'll see here in just a minute. Okay, after we've determined, yep, we're going to do a Subchapter 5 case, then we go through the takeoff. Okay, so that's preparing the petition and schedules. The Bankruptcy Code says that the way you make an election for Subchapter 5 is by designating on the petition that you're a small business debtor and you elect to proceed under Subchapter 5. Okay, so that's done on the petition, and the code says it has to be made within 14 days of the filing for relief. Okay, so you'll recall that the Bankruptcy Code says that the filing of a petition is an order for relief. So if you do an emergency petition, you've got 14 days to make that election. And so you'll want to do that at the beginning of the process.
Hey, Michael, I'm sorry.
Yep.
Just real quick, do you have to let people in, or are they automatically?
Oh, you know what? I think I do. Hold on. Thank you.
I have a bunch of people that are trying to get in.
There we go. They're all been admitted now. I'll keep a better eye on that. Okay. So just to kind of regroup for just a second. So remember that if we're going to make a Subchapter 5 election, we have to do that by checking it on the petition itself within 14 days of filing. Also, there are some dates that tend to trigger automatically based on a Subchapter 5 election. Okay, so the two that are most common are a designation of an 1111B election deadline, and then the other is a claims bar date. Okay, but neither of those are specified within Title 11. Instead, those are usually established by local rules. Okay, so about a year or so ago, here in the Central District of California, we kind of created a model rule that's used for Subchapter 5 cases. We went all over the country, got everybody else's local rules, consolidated them all together, used the kind of standardized proposed rule. And one of the things that we noted that was necessary was how you establish a claims bar date and an 1111B election. So 1111B elections are typically done when you have a disclosure statement that's approved, but a Sub 5 doesn't have a disclosure statement unless the court orders one. So check your local rules and see if those dates are automatically established by local rule. And they probably have a claims bar date that's automatically established, and the 1111B might be established. If it's not, then you're going to probably want to do a motion to establish that pretty early on in your case. All right. So we've got the takeoff. We have a live case now. Then what happens? Then we go through the plan development stage. So this is where we start putting together our plan, how we're going to treat people, whether we're going to be liquidating assets, all of those kinds of things. And we'll also engage the balloting process. Goes significantly faster than would happen in a traditional Chapter 11. Okay. Then the end result of this, after we get our balloting all done, is we go through the landing phase where we have a confirmation, and then we start planning this, and then we pay the trustee who's come into the case earlier, and then we're off and running. Okay, let me give that to you kind of like a timeline. Okay, here's the typical Subchapter V timeline. And as you look at this, jump to the end. 6 months after you file, you'll probably have a confirmed plan. Okay, so it moves dramatically faster. By statute, the court is required to have a status conference within 60 days of the filing of a petition. And at that time, you have to make an actual report to the court. It's required under the code as to what progress you have made for a consent plan. Okay, and then you're required to file your actual plan within 90 days. You have to have about a month for balloting and objections. And then after that, the court can confirm your plan. Okay, so it's very realistic to go through a Subchapter V case where you go from beginning to end. And by end, I mean final decree, case closed, 8 months. And you're in and out 8 months. Okay, so these are, again, designed to be very fast, very streamlined, and supposedly simplified. Okay, but they're just like every other Chapter 11 case, there's a lot of nuances that can kind of come in and complicate things and potentially derail it. But speaking as primarily a debtor's counsel, usually what I have found is when people want to derail a Chapter 11 case, they attack the disclosure statement. Because there is no disclosure statement, they can't do that. They also can't threaten to file a competing plan because only the debtor can file a plan. And then they also don't have the ability to go out and try to secure everybody to not vote for your plan because, amazingly enough, you can confirm a Subchapter V plan with no support from your creditors at all. Okay, so it's kind of like a Chapter 13 in that regard. All right, let's move down and take a look at some of the real specific differences between a Subchapter 5 and a traditional 11. Okay, so as we've kind of seen through the flow chart and the planning process, a Subchapter 5 case is kind of designed to be like a Chapter 12 for a non-farm business. And here's what I mean by that. You confirm without your creditor's consent. You still get a custom plan. You can monkey around with real estate that is secured, where you have secured debt against your residential real estate. Okay, so there are parameters that apply to that, but unlike the other chapters of the bankruptcy code, you can do that. So if you have a business owner that takes out a line of credit secured against his residential real estate, and then the business goes bonkers or whatever, it dies, whatever should happen, then he can change the terms of that lien secured against his residential real estate. So that is a unique novelty of the Chapter 11 Sub 5 case. You have limited eligibility for debtors. Not anybody can be a debtor under Sub 5. Have to be a small business, but with a qualification. Okay, we'll see it here in just a minute. And you have to have a debt limit of about $7.5 million. Okay, that's going to probably change again here in about a year, but that's what it is right now. That wasn't what it was going in, but it's already been adjusted. There's no absolute priority rule under Subchapter 5. Okay, so the code says that 1129A15, the absolute priority rule, does not apply in a Sub 5 case. Okay, so a lot of people filing sub fives are individual debtors. And so that's significant. Congress tried to do away with absolute priority for individual debtors in BAPSIPA, but the court kind of resurrected it. So there's a split in the circuits on that, but I think the majority of the circuits hold absolute priority does apply in individual cases, not in sub fives. It is explicit, does not apply. And then again, you have the ability to confirm a plan without any consenting class at all. Okay, so that's like your similarity to a Chapter 12 or maybe even a Chapter 13. As long as you comply with the requirements under the code, under Title 11, Sub 5, the court says, the statute says that the court shall confirm your plan. Okay, so as long as you've met the criteria, you're good to go. Now, on the screen is the opening statute for Subchapter 5. And you'll notice that Subchapter 5 starts off immediately saying, hey, there's a whole bunch of other sections of Title 11 that do not apply to cases under this title. And as you look through there, you see 1129A15, that's absolute priority rule, does not apply. Okay. The requirements for disclosure statements do not apply. And then also 1141D, you might recognize that as the statute that provides that the confirmation of a Chapter 11 plan enters a discharge, acts as a discharge. It does not act as a discharge automatically in a sub 5 case, depending on whether or not it is a consent plan or a non-consent plan. Okay, and we'll see that here in just a moment again. There's a new character in sub 5. They didn't exist until last year, and that's the Subchapter V Trustee. Now, the Subchapter V Trustee has defined roles by the statute. We'll see that here in just a minute, but just at this point, recognize that there is one, okay? They might be standing. They could be a standing trustee, or they could be just an individual appointee for that particular case. Here in the Central District of California, we do not have standing trustees for sub 5. We have a panel of individuals who are appointed in those cases instead. Okay, there's the 1193, which deals with the ability to adjust real estate secured against a debtor's residential property. Only the debtor can file a plan under Subchapter 5. Okay, so again, kind of like a Chapter 12, only the debtor can do it. So nobody else can, creditors cannot. A creditor committee, if there is one, probably won't be. But if there is one, they cannot file a plan. Only the debtor can file a plan. And only the debtor can modify a plan. So if the plan has been confirmed, the debtor and the debtor alone has the ability to confirm a plan or to modify a plan. I wanted to go back to that inapplicability section again to point out subparagraph B of that. So take a look here, okay? Subparagraph B designates that there are some provisions of the code that do not apply unless the court issues an order for cause. Okay, now there are other provisions of the Bankruptcy Code or Subchapter 5 that also require the court to issue cause, to say there's a reason why we need to do that. And the biggest ones that do that are things like a disclosure statement. Okay, so the code actually says that there's no disclosure statement except for cause. Now, I've never kind of gone down to the wire on this one with a judge, but it seems like the judges oftentimes around here anyway are inclined to order disclosure statements anyway. But the code says they're not supposed to do that unless there's a finding of cause. The same is true regarding creditor committees. Okay, so 1181B says that 1102 and 1103, those are the creditor committee provisions, do not apply absent a finding for cause. Okay, so oftentimes that initial status conference that takes place 60 days after the filing of the case, the court's going to ask, is there cause for a creditor committee? I haven't seen one appointed in a sub 5 case yet. That's not to say that it won't happen. I just haven't seen it. Okay, maybe you have, but I've seen plenty of disclosure statements ordered, no creditor committees in any sub 5 case. All right, and then the others we've already talked about, no competing plans. 1191, you're going to want to get to know real familiar, because that's the distinction between consent and non-consent. Okay, consent's 1191A, non-consent's 1191B. 1191C designates what criteria must be met in order to confirm without consent. Okay, but we'll look at that here in just a sec as well. And again, no U.S. trustee fees, but the subchapter 5 fees can be very high. So you might be cautious if you have a super simple case, in that a subchapter 5 election may end up costing the case a lot, because the debtor's effectively going to be paying 2 legal fees, 2 lawyers. They're going to pay the subchapter 5 trustee, and then they're going to pay the debtor's counsel. Okay, so just be aware of that when you're going in, and make sure you factor that into your planning. Here's 1191 that deals with the terms for confirmation. Okay, so 1191A is the consent confirmation. Okay, you confirm under that by meeting all the criteria of 1129A, but you'll notice it says, other than paragraph 15. Okay, paragraph 15 is absolute priority rule. So other than that, you're good. And the biggest criteria in that one is consent of the creditors. So if the creditors are all thumbs up, baby, let's do it, you're golden. Okay, you're going to confirm your plan and everybody's going to be happy. Okay, now remember, it still has to be legal, right? So a judge can't just do anything that everybody's okay with unless it's legal. So as long as it's legal, you're good. Then we have the criteria for a non-consent plan, and that's under 1191B. Okay, so this is commonly known as cram down. The same term is used in the subchapter 5 world. And as you go through this one, you'll notice that it says the court can still confirm a plan without, as long as we meet 1129A standards, except for section 15. That's the absolute priority. But then notice they add 2 more, 8 and 10. That's the consent provisions. So what 1191B says is you can confirm a plan with no creditor at all consenting to confirmation of your plan. But there are requirements under 1111B or 1191B, and that is that the plan must not discriminate unfairly. Okay, now note it doesn't say you can't discriminate. It says you can't discriminate unfairly. So as long as you convince the court it's fair, you're good. It has to be fair and equitable, and then you're green. And fair and equitable is defined right there in 1191C. And what fair and equitable requires is essentially that you pay all of your disposable income over a period of not less than 3 years and not more than 5 to the payment of your creditors. Okay, so if that sounds kind of like chapter 13 and chapter 12, it is. It's the same kind of idea. You take your income, subtract your expenses from it, that leaves you disposable money. You pay that disposable money to your creditors and you're good. And of course, you have the ability to really massage the numbers a good bit when you're determining what your budget's going to be. And one of the things that you get to do, which is like a gigantic slush fund, is designate money that's essential to the continued operation of the debtor. Operating capital, reserve funds. So you can park a whole bunch of money in that and take it out of line. But don't be unfair to your creditors, or you may find the court not being very receptive to you. Okay, so even if your creditors aren't on board, you still have to get the judge to sign in and say, all right, this looks good. Okay, so it's not the same exact criteria as a Chapter 13 because your disposable income is calculated under a means test there, but it's similar. Okay, it's the same kind of idea behind that. All right, so again, 1181B designates that 1125, that's the disclosure statement requirement, is not found in sub 5 unless there's cause, finding of cause by the court. The plan length typically is 3 years. The code says, as we just looked at under 1191C2, that the plan can be extended up to 5 years. Okay, so that might be that the debtor wants to do that, but usually it's the creditors want to do that so that they can squeeze more disposable income towards the payment of their obligations. Okay, now here's another very, very significant difference between a Subchapter 5 case and a traditional Chapter 11. In order to confirm a plan without the consent of your creditors, 1191C3 requires that there be a mechanism within the plan that will give protection for the general unsecured creditors. So in other words, yeah, we'll confirm this plan, but we have to have some confirmation that you are going to actually do what you say you're going to do. Okay, so if we're going to confirm this without everybody being on board and we're going to force it on creditors, you have to actually do what you say you're going to do. And then we're going to provide some protection mechanisms, and we'll talk about those, I think the third session down the road, as to some of those things that you can do. But there are plenty of them, and it is a requirement for cram down confirmation under 1191B. Okay. Discharge. You don't get a discharge on confirmation unless it's a consent case. If it's consent, then the court enters the confirmation or enters the confirmation order as a consent plan, 1191A. The discharge enters right away. Now that's a distinction from the traditional Chapter 11, even for individuals, because in an individual traditional case, it requires the payment of your disposable income for 60 months. But here, if you confirm under Subchapter 5, it doesn't. Okay, so under Subchapter 5, even for an individual debtor, if you confirm by consent, you get your discharge immediately. And then after about 60 days of doing some wrap-up admin stuff, fee applications and such like that, the case is going to close and it's going to be over. Okay, so you can go start to finish in about 8 months in a Subchapter 5 case. Okay, now let's talk about eligibility. Who can do this? Who can be the Sub 5 debtor? All right, so in Chapter 12, you got to be either a farmer or a fisherman. In Subchapter 5, the definition of debtor is given in the code in Subchapter 5. So it's in 1182. There's an issue here. I'm just going to present it for you. We're not going to go into a lot of detail on it, but be aware that it does exist. 1182 uses this phrase. Okay, let me just throw the statute on here. All right, so there's 1182. And here's what the term debtor means. It means a person engaged in commercial, and then look at this, commercial or business activities. Okay, so he's got to be engaged in commercial or business activities. But notice what it doesn't say. It doesn't say the business has to be operating. Now, you might be kind of scratching your chin saying, well, how would you be involved in commercial or business activities if the business isn't operating? And the answer is because you may be winding up the affairs of a failed business. And if you're in the winding up phase, you're still engaged in activities related to that business. So this is a current issue in the Subchapter V world. Is there in the Subchapter V world a business activity underway if the business is not currently operating? And let me tell you how split courts are on this. Not only are the circuits split on this, okay, and I don't believe there's been any appellate action on that issue yet, but even within the circuits, the districts are split on that. And even within the districts, the judges are split on that. So judges don't even agree with each other within the same district as to whether the business has to be operating or not. Okay, so if you do a check on that, you'll see that some judges are saying you got to be operating. Most judges say that you do not. Okay, but that could be an issue if you're wrapping up the affairs of a failed business. And usually what you're doing there is you're now an individual debtor and you're wanting to monkey around with a lien on your residence. Okay, so that you can do under Sub 5, even without consent of your creditors, as long as you meet the definition. Okay, there's a requirement of total debt. So there's a debt ceiling, $7.5 million. Prior to COVID and CARE Act, it was 2.7 million. So it's been adjusted. There's discussion at the legislative level as to whether that 7.5 is going to remain in place even when we're done. Maybe it will, but right now it's 7.5. Be watching for that though. It's a little bit dynamic. It could adjust back down. And then there's a prohibition against a publicly traded company, right? And that would make sense because the goal here is to deal with kind of like the family business, okay? Not a publicly traded company, but a family business. Again, the similarity with Chapter 12. So that's under 1182, the definition of a debtor. So make sure that we meet the definition of a debtor before you pull the trigger there, and then you're off and going. Okay, discharge. We spoke about that a moment ago, so I don't think we need to talk about it too much more, other than, again, just to say, if you confirm as a consent plan, 1191A, you do get a discharge on the entry of the confirmation. If you're doing a cram down plan, non-consent, you don't get the discharge until the 36-month plan has concluded, unless the court has ordered that you do a 60-month plan. All right. Now, let's talk about this new mysterious guy called the Subchapter V Trustee. Who is this guy? What's he do? How's he get paid? When does he get paid? Okay, these are all questions that you have to address mostly during the planning period. Sometimes during the plan creation period, when you're kind of putting it up, you're at that cruising thing, you're putting the plan together, but usually before you even file. What are we going to do here regarding this fellow? All right, he's under the code, so he is a officer of the case. So if you look at 11 USC 1183, that's part of Subchapter 5. It designates that the U.S. trustee has to appoint a Subchapter V trustee. Can be one of two things. Either he can be a standing trustee, see that, standing trustee, if the U.S. trustee has designated such an individual. If they don't use a standing trustee, then it says otherwise the court or the U.S. trustee shall appoint one disinterested person to serve as the trustee. So what my observation has been is that typically what courts do is the U.S. trustee in the various districts have not a standing trustee, but a panel of trustees that they draw from and assign to these cases when they kind of come through the list. The way they get paid differs. If they're a standing trustee, they're paid kind of like the Chapter 13 trustee. They have a statutory formula. If they're just a disinterested person, they just get approved. Their fees are approved by the court, and then we have to pay them. Okay, and how we pay them is going to differ based on whether it's a consent plan or if it is a cram down plan. Okay, here's what they do. Okay, so this is, again, by statute, their duties are assigned here, and they're kind of what you would expect, right? So they go to the 341. They go to status conferences. They chime in on the value of property or a lien. They make comments whether they think confirmation is a good idea or not. They get to contribute to discussions about modification and the sale of estate property. The two big things that the Sub 5 trustee does is that number 7 in that list, facilitate the development of a consensual plan of reorganization. Now that means that he's not like a creditor committee. Okay, he kind of acts like a peace broker. Let's see if we can coordinate some kind of deal, almost like a mediation sometimes, between the debtor and his creditors. And because of that, let me tell you, if you're a debtor's counsel, you want to engage this guy quick. You probably want to contact the Sub 5 trustee and say, hi, I'm debtor's counsel in this case. Here's kind of what this case is about. Here's where we could use your help on getting a consent plan. Pitch your deal to them and recruit them to help you get a confirmation by consent. By statute, that's part of their job, okay? The second big part of their job is after confirmation, they act as a payment conduit, just like a Chapter 12 or a Chapter 13 trustee. You send the payment to them, and then they disperse it in accordance to the plan. So that's what Sub 5 trustees do. Okay, they come into the case right after it's opened, and they're appointed by the U.S. trustee, and they leave the case either upon confirmation of a consent plan, when you have substantial consummation, which requires the debtor file a notice of within 14 days, say, okay, we got it, substantial consummation, we're performing, we're doing what we're supposed to do. Then the Sub 5 trustee waves goodbye, he's done. Okay, if it's a consent plan. If it is a cram down plan, he's going to be your pal for the next 3 to 5 years because he stays in the case as that payment conduit. And he's going to be watching to make sure that your debtor's performing and doing what it is that they said they would do. So that's one of the things that you typically look at and say, well, I would much rather have a consent plan so that I can shut this thing down. I can come in and out in about that 8-month window of time. And then my debtor can ride off into the sunset and pay all their creditors and do what it is that they said. And then everybody's happy. Otherwise, I've got this third guy watching me all the time. And he's being the conduit to get all these payments in. So most people would rather not have that happen. But there may be times where it is advantageous to do that. And we'll talk about this next session mostly, but the biggest one is that you have to pay that guy, the Sub 5 trustee. You have to pay the Subchapter 5 trustee their fees on confirmation or with terms that he agrees to. If it's a cram down plan, he gets paid through the plan just like everybody else. So if you've got like a big amount that you're going to pay the Subchapter 5 trustee, being able to stretch that payment out over 3 to 5 years may be a reason for you to not seek confirmation as a consent plan, but instead to go with a cram down plan. Okay, just one of the factors you kind of have to throw into the mix. All right, let's talk about the estate property. And then after that, we'll take some Q&A and see what your thoughts are all around the country here. Okay, so what constitutes property of the estate? Well, when you file the case, it's all the property that the debtor owes, right? So it's the same concept of any other Chapter 11. When you file the case, the debtor kind of virtually hands everything over to the Chapter 11 estate, and then he manages that estate for the benefit of his creditors. In a Subchapter 5 case, there's a difference that happens, though. In a traditional Chapter 11 case, the property of the estate revests back in the debtor on confirmation unless the plan provides otherwise. In a Subchapter 5 case, that's not what happens, okay? If it's a consent plan, that is what happens, okay? So if it's an 1191A consent confirmation, then the estate concludes at confirmation, everything's all done, we're finished. So the property goes back to the debtor and you're right off into the sunset. On the other hand, if you confirm your plan as a cram down plan, the estate does not conclude a confirmation. So the property doesn't just revest back in the debtor, but it can instead kind of hold on. And that's one of the things that you would typically do as a debtor in order to get that 1191C protection for your unsecured creditors into your plan and confirm. That's a common option. Don't revest property in the debtor, but instead allow that to remain in the estate. And then if you end up converted to Chapter 7, those assets are available easily without them being sold or otherwise disposed of by the debtor. They're retained. You'd have to have court authorization to sell property of the estate. That would still be true post-confirmation, and that provides protection for your debtors. But the estate also keeps growing. So if you have a confirmation under the cram down provisions, 1191B, the estate property also includes post-confirmation property. So things that you acquire after the confirmation and earnings. So liquid capital sitting around in the guy's bank account, all that stuff, just like what would happen in a Chapter 13 case. And then if you get converted to Chapter 7, then all those things become assets of the estate that are potentially subject to liquidation, unless they're exempted. All right, here's another, again, reminder. Because we're not paying U.S. trustee fees, there's no rush to close the case. Okay, you are going to incur Subchapter V trustee expenses, but you only incur those as they actually happen. In other words, if the trustee is not doing anything, he's not getting a fee. He's only getting a fee if he's doing something, if he's being a payment conduit or if he's chiming in on motions and things like that. But if he's just kind of sitting around not doing anything, he doesn't get paid. And the U.S. trustee doesn't get paid. So you don't have to rush to close this thing up and get an administrative closure or something similar in an individual case. You probably still want to, just so you can kind of wrap it up, but there's not as humongous of a need to do that as would otherwise typically happen. All right, here's probably the penultimate question. Are there circumstances where you could file a Subchapter 5 case, but are better off not doing so? Probably not, okay, unless it relates to U.S. trustee fees. Because the benefits of Subchapter 5 are so tremendous for the debtor. No need for consent of any creditor, no absolute priority rule, no U.S. trustee fees, no competing plans, no creditor committees, no disclosure statements, an enhanced speed. The benefits to the typical debtor in a Subchapter 5 case are in fact significant. Okay, so You may, the ability to play around with liens secured against the residential real estate. There are significant advantages. All right. But if the U.S. trustee fees are going to be enormous, like maybe you're selling a large commercial building, if you're going to have, $5 or $10 million moving through the estate, then that's going to be a humongous fee for the U.S. trustee. So in those cases, you'd say, nope, I'm gonna stay in my subchapter 5 case. On the other hand, if you have a really tiny case where you've only got a relatively small amount of creditors and relatively low income, like it's a winding up case, in those instances, you may find that the subchapter 5 trustee fees are really, really big and out of scale or out of proportion to what it is that you're accomplishing in your sub 5 case. All right, so that is the whirlwind approach to the differences between subchapter 5 and a traditional chapter 11, and a reason why you might want to file one instead of the other. And now we want to kind of shift gears a little bit as we conclude our time for about the next 10 minutes or so, and see what is happening otherwise around the world or around the US. So we have a time now for any kind of questions or discussions or things that you may have seen, things that may be different in your practice versus what's happening here. I'm in Georgia and California. And so we have time now for just open forum and questions.
Hey, Michael.
Yes,
This
sir.
is Ryan. Mr. Buck asked a question on chat, if you want to look at the chat.
All right, hold on.
How are contingent liabilities valued for purposes of the debt limit, e.g. guarantees?
Okay, so let me go back up here to the definition of debtor again. And so the debtor says specifically under B, so 1B, says it does not include any member of a group of affiliated debtors. Okay. Oh, pardon me. We can stay up here in A. So when we're looking at the debt amount, it says where the aggregate non-contingent liquidated secured and unsecured debts are an amount not more than 7.5. Okay. So it has to be non-contingent and liquidated. If it's contingent or unliquidated, it doesn't factor into the debt limits. So in that regard, it would be similar to the debt limit provisions of a Chapter 13 or a Chapter 5, so or Chapter 12. Sorry, in a Chapter 12 case, it's 5 million. Same idea, and in a Chapter 13 case, it's much lower than that, but it's the same idea. You may, however, find yourself suddenly ineligible if your debts go up, but because you can go through this thing so fast, you may be able to get a confirmed plan and be done before any of that stuff matters. Okay, hope that helps. All right, and then looking at the chat, I see that we have another question too that says, can you close the case quickly after the plan is confirmed under 1191B and avoid the post-confirmation property issue? Okay, so what 1191B, that's the cram down provisions under subchapter 5, what that passage or statute kind of envisions is that the case is going to stay open. Now it's normal in a traditional Chapter 11, particularly if you have an individual debtor who doesn't get his discharge until the end of 60 months. It's normal for that debtor to go and ask for a, quote, administrative closure of the case. And there, the whole thing shuts down. It's just the debtor keeps performing. And then he comes back 5 years later and says, hi, remember me? I was here 5 years ago. I would like to now get my discharge order. I've done everything the plan said. So that happens in a traditional 11. But in a subchapter 5 case, it's kind of envisioned that the case is going to stay open. But subchapter 5 doesn't say that. and section 101 or 105 that allows the court to issue orders consistent with the bankruptcy code would probably allow an administrative closure just like it would in a traditional 11. So you could try it and shut it down. The trustee is probably going to oppose that, because if it's an 1191B, the trustee acts as the payment conduit and he gets paid for that, and his payment gets approved by the court. And if the case isn't open anymore, I don't see how that would easily occur. So you could try, but I don't know that it would necessarily work. Okay. And then I've got another question that's in the chat. It says, in cases where the courts, such as in California, have required a disclosure statement, has that been a motion filed by a creditor or on the court's own initiative? Okay, my experience has been that it's the judges doing it. What happens with the judges, and I've had 3 different judges who, now we've got like 30 judges here in the Central District, but we've had 3 of them who have all just on their own come right out of the gate and said, you have to do a disclosure statement. A 4th judge required that you do a combined plan and disclosure statement, kind of like what you would do in a small business case anyway. And so what judges, I think, are doing is they're just uncomfortable with the idea of having a plan go out without a disclosure statement. Now, next time around, when we're talking about the plan drafting, we'll deal with this in more specifics. But the plan requirements under Subchapter 5 are unique. They require most of the substantive stuff that would normally be in a disclosure statement. So, I mean, so much so that in those cases where our firm has been required to file a disclosure statement, we just file the plan essentially twice, entitle one of them the disclosure statement and one of them the plan, because they're both the same stuff. They both have the same provisions, the same projections, the same stuff that could go wrong, the same financial history. So in a traditional Chapter 11, here in our office anyway, a plan might be about 30 pages long and a disclosure statement about 70 pages long, 70 or 80 pages. And in a Subchapter 5 case, you're going to find a Sub 5 plan. It's going to be more like 70 or 80 pages long because it includes all the stuff that used to be in the other. Okay. Then we have another question that says, if and when a prospective client asks how much a Sub 5 case is going to cost with professional fees, trustee fees, etc., how do you typically respond? Okay, the way I typically respond is to say, I don't have a crystal ball to know the future, but I can give you a reasonable estimate. You should probably expect the US or the Sub 5 trustee fees to be about half of what the debtor's fees are going to be, debtor's counsel fees are going to be. Now that's just a rule of thumb, and it could vary from district to district. But if you have kind of that as a ballpark number, you'll probably be about in the range. Okay. So you don't have US trustee fees, but you do have, again, those fees. So think about what your normal debtor's counsel fee would be, take about half of that, and so that's probably what it's going to be. Now, again, we'll talk about this next time when we do plan drafting. But if you're paying the Sub 5 trustee a fee to act as a payment conduit, he's going to also get a bunch of money over that 3 to 5 years by being the payment conduit. If you factor out how much you think that's going to be, like let's just use a simple number like 20 grand. It's going to be 20 grand. What you might want to do in your drafting is to create a provision in your plan, kind of like a death trap provision, but that's beneficial to creditors. It's a bonus that says, hey, we're going to probably pay the Sub 5 trustee 20 grand over 5 years for doing his job. We'd rather just pay you. So if we confirm this thing under 1191A, we're going to create a pot of about 10 grand. That's half of what we'd pay the other guy. And we're just going to give it to the creditors instead. And then distribute that pro rata to all your creditors in the case. And then what you've done is you've saved your debtor money, and you've probably also created a large incentive to get creditors to vote for your plan. So that's another thing that you might contemplate. And we'll talk about that next time around with our plan drafting too. Okay, another question that's in. Do you believe that Congress will extend or make permanent the $7.5 million debt limits for Subchapter 5? And from your experience, is $7.5 million limit high enough to provide a sufficient number of small business bankruptcy relief? Okay, my answer to both of those is probably it will be continued. And yes, I think that's about the sweet spot. Larger manufacturers or large office buildings and things like that may have debt limits above that. But if you're a single asset real estate, you're not eligible as a debtor under Sub 5. So in those cases like that wouldn't work anyway. The target here's like our office's typical Subchapter 5 debtor. A multi-unit restaurant chain, like 3 or 5 places, a small retail operation, somebody who tried a brokerage business and it failed, and now they're in a wrap-up. A person that has a few rental properties, but more than one, so they're not like a single asset real estate case. These are the kinds of cases that are Sub 5 cases. The ones that are large real estate holdings, probably not. The ones that are larger scale manufacturers, probably not. Although a medium-sized manufacturer would be, yes. So we have medium-sized manufacturers that still do, a pretty large amount of revenue a year, but they don't have a gigantic amount of debt. And a lot of times their debt, when they're wrapping up on a thing, is like the landlord. So those are the typical kinds of cases. All right. And then we've got maybe one more question, and then I think we're going to be out of time since we only allocated an hour. So the last question that we have here says, under a consent plan, can a Sub 5 trustee agree to payment of fees over time, notwithstanding the right to payment upon confirmation or the effective date? And have you seen a trustee agree to such a treatment? Okay, so the answer is yes, he can. He can agree to do that. And have I seen them do it? I have seen them do it as long as what's proposed is not unreasonable, still quick, and essentially necessary to confirm the plan. So like if the debtor's only got like $15,000 of liquid capital in the US and the Sub 5 trustee fees are going to be 10 grand, that's probably not going to work. He's not going to have enough operating capital going in. So in those instances, our office's experience has been that a Subchapter 5 trustee would agree to payment over like 3 to 6 months, something like that. All right. So that's our hour. We are done with the distinctions between Subchapter 5 and traditional 11s. Next time around, we'll have more nuts and bolts about actual plan drafting and planning and how we can work these things to our benefit. But I'll turn things back over to the CPT guys.
Thank you, Michael. That was excellent. Thank you, everyone, for attending. Like Michael said, this is first part of a 3-part series we'll be doing over the next 4 or 5 months. So be looking for the invites. We'll make sure that every one of you is on the invite, and so that you can RSVP and enjoy the next class that we do. Thank you so much, and please consider CPT Group for your notice and claims. Thanks so much.
Thanks, guys. Have a joyous day.